So I have an important update on the current battles against Illinois and their ban on so-called assault weapons. There's been some significant developments that we need to talk about. But real quick before we jump into this video, I want to ask you guys for a huge favor. The channel right now is just sitting below 600,000 subscribers. I was looking at some of my analytics and about 60% of all my viewers across the channel are actually not subscribed to the channel. So if you've been watching this channel for a long time, if you enjoy these videos, please consider subscribing to the channel. It will help to not only grow the channel, but it signals to the algorithm that it should push this type of content out to more people so that we can inform more people about the 2A movement and things that are going on that affect our right to keep and bear arms. As I mentioned in the intro, in this video, I have some important updates in the current battles, which are attempting to strike down the state of Illinois' ban on so-called assault weapons. We're going to be breaking down how millions of law-abiding Americans woke up in 2024, now potentially as felons, simply because they own the most common rifles and magazines in the entire nation. Millions of people in Illinois now face serious criminal convictions because the 7th Circuit, the en banc panel there decided to directly defy what the Supreme Court said in their rulings in the Bruin case. And even worse, the Supreme Court itself has been unwilling to hold these lower courts accountable on this issue. However, there is a little bit of a glimmer of hope that we need to talk about as well. A bunch of cases have now been fast-tracked through the process, which may give Illinois residents some protections. As you may recall, recently we received news that the U.S. Supreme Court denied 2 emergency injunctions, which were asking for the U.S. Supreme Court to put a temporary halt on the statewide rifle and magazine ban. Those cases, which we talked about, were the Colkins v. Pritzker case, and then also the NAGR versus Naperville case. These cases involved a challenge to the Protect Illinois Communities Act, or PICA, which places unconstitutional restrictions on rifles and magazines. PICA also requires a registration requirement to essentially grandfather in those rifles and items that were already possessed, which means that there was a registration period, but now it's closed starting in 2024. That means that millions of Americans in the state of Illinois who did not register firearms or various parts which needed to be registered are now open potentially to serious charges because of this unconstitutional law. The Colkins case, which we've talked about, was a case originally brought in a state lower court, state of Illinois state court case. And essentially on review, the state court judge there issued a summary judgment against the state of Illinois, finding that this ban was unconstitutional and, denied equal protections under the state constitution. Now, in response to losing that case, the state of Illinois appealed the decision up to the Illinois State Supreme Court. So the Illinois State Supreme Court got involved, reviewed the case, reversed ultimately the lower court's decision, and that then led this case to being, sought for review in the U.S. Supreme Court. One of the main things that also happened in that case is there was a request for an emergency stay. However, the U.S. Supreme Court ultimately denied both the request for an emergency stay and then also they denied taking review of this case because they held a conference on January 5th on whether or not they would take an actual review of this case, and ultimately they decided, no, we're not going to take review of this case either, and also we are going to deny the request for an emergency stay. Now, the second case that was denied the emergency request for a stay was the NAGR versus Naperville case. In the NAGR case, the plaintiffs also filed for emergency intervention, but again, the U.S. Supreme Court denied the request for an emergency stay. Then also the 7th Circuit en banc panel denied review in the NAGR case, and they also denied review in a bunch of other cases, that were challenging PICA. So that was not looking good at all. The U.S. Supreme Court didn't want to get involved, and then the 7th Circuit en banc panel also did not take review of any of these cases. However, NAGR still has options, like a lot of these other cases. They can still seek Supreme Court review, but as of right now, a bunch of these cases have not actually filed for traditional writs of cert. So we're just kind of waiting to see what will happen. So the Supreme Court to this point has decided not to get involved in any of the Illinois bans on so-called assault weapons, and the 7th Circuit has also decided to deny en banc review in multiple cases. That essentially has left the battle to take place in the lower courts. Recently, we talked about how there was a last-ditch kind of Hail Mary, and that was in the lower courts in front of Judge McGlynn, and they were asking for the circumvention of the 7th Circuit and those decisions, and that was in the FFL versus Pritzker case. However, the judge there, Judge McGlynn, denied the request for a new injunction. He denied that new request and then also dismissed the Fourth Amendment challenges that were brought in that case. But essentially what he'd said in that order was that the higher courts and their precedent and what they just said essentially just ties his hands together. He can't do anything. He can't issue a new injunction that would circumvent the rulings that were already issued. And mainly that's because the higher courts had said that they want a merits decision. So what he said in his recent order is that he's going to expedite all these cases to actual merits decisions. And that's exactly what is now happening, and that's exactly what Judge McGlynn is doing. Judge McGlynn recently held conference in multiple cases. Those were the Langley cases, I believe, the Barnett case, the FFL versus Pritzker case, and some other ones as well. All these cases were heard in front of Judge McGlynn. There was a conference, and the question was, how are these cases going to proceed forward? During that hearing, Judge McGlynn represented to all the parties that he intends to move these cases along as fast as possible to actual merits decisions. He is setting these for expedited review. Now, some of the plaintiffs, like the FFL versus Pritzker plaintiffs, in that case, they represented to Judge McGlynn that they still intend to seek Supreme Court review. There were multiple parties, including some of the plaintiffs and also the state's representatives, who are asking for Judge McGlynn to delay the lower court review, to delay these cases because the Supreme Court certs were going to be filed. But Judge McGlynn told all the parties during this hearing that he is not going to delay these cases any further. He told them during this conference that if they file certs and ultimately something changes where the Supreme Court grants review of these cases, well, then they will address that when it comes up. But he told them that the Supreme Court has turned down preliminary injunction requests multiple times, like we just talked about, like I just broke down in Colkins and NAGR. Multiple times, the Supreme Court has said, no, we're not going to get involved in these cases at the preliminary injunction stage. We are waiting for the record to be fully developed. And that is what he's going to do. Therefore, that is how he's proceeding forward. In all these cases, he is moving them towards an actual merits decision. He then also told the parties that he's going to keep all these cases on a short leash, which means he's going to try to move these forward as fast as possible. He then also inserted some interesting comments during the whole discussion, where he talked about how the term assault weapon is not a scientific term and that it's more of a political term, which is very interesting coming from the judge who is going to be ruling on all these cases. He said he is going to look at every item in question and analyze essentially each of them on whether or not they are truly reserved for military use, like the Seventh Circuit recently stated. He said, we're going to look at each of these things. We're going to study each of these things. Then, having analyzed the capability, their design, their uses, then plug in the tests that are or may be applicable. As I sit here, I anticipate saying that this test is articulated in this case and test B is for different cases. Now, what I think he's alluding to here in that comment is that his decision that he will issue will probably just try to separate out certain items, saying, in my belief and looking at the facts, I think this item is purely and exclusively for military use, which again is not the test at all, but that is what the Seventh Circuit has stuck him with. He's going to say, yes, these items are only for military use, but all these other items which are commonly owned for lawful purposes by law-abiding people, that is not exclusively for military use, and therefore I use this test for these items and this test for these items. Again, that's not the test under Bruin, but that is what the Seventh Circuit recently did, and again, in direct defiance to the Supreme Court, they tried to change the analysis, but that is what is now happening. And then, as I mentioned, there were representatives from both sides who were asking for even more time, but Judge McGlynn responded by saying this is going to be an expedited docket. Kind of quoting him and looking at what he said that essentially he owes it to everybody involved in these cases and all the Illinois residents to get this resolved at the district court level, especially since the Seventh Circuit and the higher court said that this case cannot be resolved and cannot be fully reviewed at the preliminary injunction stage and based on the preliminary injunction relief. A record needs to be developed. Therefore, he's going to move this forward to declaratory judgment. McGlynn said that he was instructed to develop the record even further, and that is what he's going to do. He said that I don't think an evidentiary hearing is going to be that complicated. I don't think discovery is going to take a long time. The government has a position on why it legislated the way that they did. The plaintiffs disagree with it, and under existing case law, the facts are some or all the items cannot be banned and are protected by the Second Amendment. So again, very interesting. What this means is that looking forward, if you're an Illinois resident, if you're very concerned about this issue, what's going to happen is there's going to be expedited reviews and decisions in a bunch of these cases at the lower court level in front of Judge McGlynn. He's trying to get this stuff done and essentially force the Seventh Circuit to ultimately review these cases. He also stated expressly that right now he is not going to stay any of these cases. He's not going to halt any of these cases just because Supreme Court writ is sought in some of these cases, which are going to be coming. A lot of the attorneys for these sides in these cases have represented to Judge McGlynn that they intend to file cert petitions, which are probably going to come here in a few weeks or a couple weeks. We're going to probably see, maybe 2 or 3 of them filed, but he's not going to actually halt the lower court's review of these cases until the Supreme Court actually grants review or does something. So that's what's going on in Illinois. Again, not great news. The Supreme Court certs are potentially coming very soon. I'll update you guys when that happens. There's expedited review in the lower courts in all these cases. The judge is trying to proceed forward as fast as possible. But if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.